Yes. Yesterday we have extensively dealt with the provisions of offences affecting the administration of justice. How, when the perjury is committed by the witness, because you have been clearly, we have brought before you that under the Evidence Act, the witness cannot excuse himself from answering, whereas under the Constitution of India, he can claim protection from answering, whereas under the provisions of CrPC, where offences affecting the administration of justice takes place, complaint is filed under section 195 CrPC by the concerned court. Concerned court is the complainant, becomes the complainant, the parties don't file the complaint. The court itself complainant. In the Bombay High Court, the Protonotary Senior Master High Court, Bombay will file the complaint. Or in the appellate side, it is the registrar judicial side will file the complaint. City Civil Court, Small Causes Court, registrar will file a complaint at the directions of the honorable judges. Similarly, in tribunals everywhere, the tribunal themselves, the member files a complaint. Magistrate himself files the complaint. So I explained to you that under section 369 of the evidence of the CrPC, a witness refusing to answer question or producing documents um, can be sentenced to jail. He can be arrested by awarding sentence for 7 days. 7 days, isn't it? That is a procedure followed, is a procedure with regard to contempt under section 345 CrPC. Similarly, under section 347, all civil court judges, registrars or also have a similar power we have mentioned to you. The chapter with regard to offences affecting the administration of justice is very important. You must bear in mind that means the witnesses cannot browbeat, cannot speak whatever they want in the court of law. They must, when they're taking oath, they must speak the truth. Though under the provisions of the scheme of the Evidence Act, the witness may be protected, he may not be arrested while giving evidence when questions are found to be false by pursuant to section 132. But the witnesses cannot escape the consequences of section 340 CrPC and the provisions of section 349 where they can be arrested. Please note that here. That is very important. Then after the evidence is completed, the next course of action will be before the magistrates court is submissions. Both the parties, advocates, make their written submission on oral submission before the judge for canvassing their case. The prosecution will say that they have proved the case beyond reasonable doubt. The accused will take up the plea that the prosecution had not discharged the case. So after advancing the judgments, after advancing the written and oral argument in that regard, the matter is kept for judgment. That chapter with regard to judgment is dealt in chapter 27 CrPC, section 253, 253, 254, 353, section 353, 354, 355, 356. Then 357 is with regard to compensation. This is a very important chapter. You should remember it here. The court can also award compensation to the victim, then treatment of the compensation for treatment of the victim in under the provisions of the CrPC while pronouncing judgment. Then I mentioned to you that after pronouncing judgment, after convicting the accused person, having regard to the age of the accused person and the circumstances he is placed in, his behavior, the court may also release him on probation of conduct, good conduct. That is pre-section 360 CrPC, remember Kija. Okay. That is the end of the trial. The trial has been completed in the matter. Then judgment has been granted. Then sentencing will take place. Sentencing is a separate chapter. Um, the chapter 28 deals with, as you know, that the Court of Session has the right to award death penalty subject to the confirmation by the High Court. The confirmation is done by the High Court under the provisions of section 369. The chapter is starting from 366 to Lekha 369, 371. 366 mandates that here death sentence to be confirmed by the High Court. The High Court has power to make further inquiries under 367, or further evidence can be recorded by the High Court. The High Court may say that here the evidence which is on record for conviction is not sufficient. Additional evidence must also be recorded. This is like under section 391 में पढ़े आपने. The appellate court has got the power to record evidence, further evidence. Like under the provisions of the section 173, can the police officer can further put further additional investigation can be ordered. Now here the High Court will say that here additional evidence should be recorded because the accused cannot be convicted on the basis of a slim evidence. So inquiry can be held by the can be ordered by the High Court. The High Court has power to either set aside the conviction and or confirm the sentence which is granted here pursuant to section 368. Confirmation proceeding. Now these proceedings come before the High Court before a division bench. Please note that two judges take the call whether he should be convicted, he should be hanged or not to death here. So provisions, you remember that here. Then every know that here almost every conviction which has been recorded in the criminal court, or every almost every what you call it acquittal is subject to a statutory right of appeal which are governed under the provisions of chapter 29. देखिए आप starting from section 272. I think initially when dealing with appeal I had covered it. I will cursorily today deal with the provisions of appeal. Now that here see 372 mandates that here an appeal shall not lie from a judgment and order except as provided. Appeal is a statutory right. You just cannot file an appeal against each and every order. Against interlocutory order, that normally there is no appeal. Against substantive orders which are affecting your right title interest, there will be an appeal. So the mandate of 372 CrPC clearly state that here there is no right of appeal as a matter of course unless it is otherwise provided by the court. Please देख लीजिए आप. Then provided the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequacy of the compensation. Such appeal shall lie to the court of which an appeal ordinarily lies against the order of conviction. The proviso which has been added in the year 209 mandates that here the victim should not feel disheartened that the accused has been totally discharged or acquitted and the court. So he has been provided a right of appeal. Formally the right of appeal was deprived, which was not there in every case. Now we will take you the salient features of some of the provision which provide appeal. 373 appeal from order requiring security or refusal to accept rejecting surety for keeping peace or good behavior any person. You know the 117 of the act in CrPC, you have to give a breach of peace के अंदर. Please open section 117 is a provision where the executive magistrate asks you to give a breach of peace. 117 खोल लीजिए आप. Order to give security. This is a chapter starting from section 106.1. When two neighbors are constantly fighting together, abusing each other, the powers are given to the executive magistrate. They can ask you to give a security for keeping good behavior, peace in the locality. Isn't it? यहाँ पे 108 के अंदर you are told to appear before the executive magistrate. Security for behavior 110. 117 में order is given security. When such an order is passed, is made appealable under the provisions of section 373 के अंदर देखिए. Huh? Who has been ordered to give security for keeping peace. Are you bullying? I am a respectable man. Why I have been told to give security? I am being harassed by my neighbor. There is no cause of complaint of whatsoever nature. Huh? My my right to peaceful living is being defied. My right under Article 21, the right to life and liberty is sought to be deprived. I have not done anything. The order passed by the learned executive magistrate is erroneous. So he has agreed rejecting a surety to this order section 373. Shall apply to person proceeding under the session code so and so 112 के अंदर 122 के अंदर the imprisonment in default of security would be exempted in the matter of a appeal. Now, important section 374, well, appeals from conviction. When a person is convicted in charges, a person convicted in a trial held by the High Court in extraordinary original civil jurisdiction may appeal to Supreme Court. See, normally the High Court is not a court of original jurisdiction in the CrPC. But there are cases where the High Court tries directly itself matters, for example, under section 407. 407 खोल लीजिए आप बोला बताएंगे for your information. Under section 407, the High Court has power to transfer cases from courts, magistrates, session judges. When a transfer application is filed, it tries itself. So when the High Court tries the matter itself, it becomes the court of original jurisdiction. Then another matter is you under section 96 CrPC, the खोल लीजिए 96. When a confiscation order is passed under section 95, recapitulate your memory. This we have discussed it. This will become nice your revision for you. Please open section 95. 95 confiscation. When a order declaration is passed for forfeiture of your books, any newspaper item on the ground that these are injurious to public and detrimental to the general public at large. You, like for example, Salman Rushdie's book was confiscated on the ground that if it is allowed to be read and the Muslim community may will be unrest. Mahatma Gandhi killer's book was written and the Godse's book was written, dramas were having withheld by the government. So there are many things with a view to prevent breach of peace in the locality and maintain peace and tranquility. The government can pass an order of forfeiture, and books which are totally obscene material can be confiscated. A painting of M.F. Hussain, which was regarded as not correct to the Hindu sentiments when he had depicted some of the goddess in nude, were confiscated by the police authorities and the state government. All of you know that here. Ultimately, whatever may be. So the remedy in such matter is proceedings will lie to the High Court under section 96. See, 95 के अंदर forfeiture order होगा publication के अंदर. So normally when you in a court, because under section 190 of the CrPC 190 ABC, the magistrate is a court of original jurisdiction, but there is a departure under section 95 96 when the confiscation or forfeiture of publication take place by the police officer or the state government on certain reasons, on the ground that it is likely to be involved in the commission of the offences under 153A, 153B, 292, 293 and the Indian Penal Code, which are offences disturbing the peace and tranquility and community maintaining social. All of you know that here. So your remedy is to move the High Court. You cannot go to the magistrate under 190. You cannot go to the court of session. You cannot file an appeal. You cannot file a revision. So your remedy is to come under section 91 to file a suit for declaration, an application in the Bombay High Court. This application would lie in the appellate side of the criminal jurisdiction under section 96. So this will be, I would call it here, this is the original jurisdiction of the High Court. Because this matter is required to be heard by a division bench or 3 benches judgment. Full bench judges. See that every application of the High Court consists of 3 or more judges. It's a full bench. Because it's a serious matter with regard to violation of your fundamental right under Article 21, under Article 19 of the G of the Constitution arises here. Your fundamental, the court has to cut a balance between your fundamental rights and the rights of the citizen, and rights. The offences under Section 124A, 153A, 153B, 292, 23B of the Indian Penal Code. So all of you know that these are serious offences with regard to yes. So with a view to maintain such a peace and tranquility in locality, the the state government or the central government can pass such orders, so that even a public nuisance is committed by somebody else, so the nuisance can be abated. That is how it is being done here. So 96 speaks of the matter being filed before the three benches, full bench rather. This is the court of original. So when a judgment is given or a conviction, whatever order may be passed by the High Court, when you under Section 272, please come back to 200 and, where are we? Appeals, 372. 1 minute, I will just say that. Yes. Yeah. Yeah. The appeals would lie from the High Court to Supreme Court directly. Under the Constitution of India, the Supreme Court either certificate can be granted to the Supreme Court. The Honorable Supreme Court has a criminal jurisdiction. All of you know that here, under Article 131 of the Constitution, it has a original jurisdiction, isn't it? Under Article 133 के अंदर आप चेक करेंगे, under Article 132, appellate jurisdiction of the High Court in certain cases. Then the appellate jurisdiction of the High Court in criminal cases come into play under Article 134 of the Constitution of India, and sometimes the High Court will also grant certificate under Article 134A. If the matter is not fitting, if the High Court rejects certificate under 134A, and you may also come under Article 136 in the Constitution in the absence of any statutory provision in the CPC or CrPC. But fortunately, the CrPC contains Section 374, which enables a person convicted in a trial held by the High Court. So the High Court, which has assumed power under Section 407, conducted a trial. Sometimes some special matters, the High Court is a trial court in special matters. The securities scams matter, Harshad Mehta trial court. High Court was a original court of jurisdiction which awarded punishment, isn't it? All of you know that. Earlier, the A.R. Ramtule versus Ramnath case, High Court were trying a matter as a special court. Of course, Supreme Court set aside the same, stating that High Court in that particular matter is not a special court. The matter was sent to a special. The matter was sent to the Court of Session judge here. So the legislature must mention what are the matters must be assigned to the High Court, which must act as a court of original jurisdiction. So under the CrPC, no doubt, Section 407 empowers the High Court to try certain matters being transferred from any other court to try. It is suppose if a court is convicting any person, appeal would lie to the Honorable Supreme Court of India under 374. Okay. Then subsection 2 of 374 speaks of a person convicted of a trial held by session judge or an additional session judge, which a sentence of imprisonment more than 7 years has been passed, may be a High Court. So the High Court is convicting a man in robbery cases, murder cases, rape cases more than 7 years. So appeal would automatically lie as a statutory remedy to the Honorable High Court in the city of Bombay. All these appeals lie before the appellate side of the Bombay High Court, which has a special criminal jurisdiction. Please note that here. Then there are certain appeals. Then save otherwise subsection 2, any person convicted in trial by the Metropolitan Magistrate, second class sentencing under 325 in respect of whom has been made a sentence has been passed recently by magistrate may appeal to session judge. So wherever the order is passed by the learned metropolitan magistrates, conviction order, the appeal would lie to the court of session under subsection 3. Please note that here, section 374 is into 3 heading. Number 1, the 374 1A speaks of appeals from High Court's conviction to the Supreme Court, and conviction from the from the judgment of the session court to the Honorable High Court, and from the conviction from the court of magistrate, the appeal would lie to the court of session judges. Okay, then when appeal has been filed against sentence passed under 376, 376A, A, B, C, 26 A so and so Indian Penal Code shall be disposed of within a period of 6 months' time. These are rape cases. 37, the mandate is that here there is a legislative mandate. There must be expeditious disposal of 6 months from the date of filing of the appeal, but unfortunately it doesn't happen on account of paucity of judges. That we can't blame it. Then 375 says that no appeal lie in certain cases, accused plead guilty. So naturally when you plead guilty, no appeal lies. Like under the Code of Civil Procedure Code, an ex parte decree is passed, consent decree, no appeal lies. The analogous provision section 96 check karo CPC ke andar, these are, you must know that here I am pointing out to you, section 96 ke andar, the High Court and the District Court are the court where the appeal lies directly under section 96. Remember that here, the provisions of section 96, the appeal from original decrees, the original decree, an appeal going from a district court to High Court is called first appeal. An appeal going from civil judge junior division, senior division to the district court, first appeal. Going from district court to High Court is also first appeal. Then an appeal may lie against some ex parte decree also 96(2), but there shall be no appeal against a consent decree. Subsection 3 देखिए आप, no appeal shall lie from a decree passed by a court with the consent of a decree. Now, as regard the the appeal to the Supreme Court of India, you know that specific provision is there in the CPC, appellate powers of the how the appeal goes. Appeal may lie, section 109, when appeal lies to Supreme Court. So under the provisions of a CrPC, the provisions of section 374 appeal to Supreme Court, in the CPC, the appeals to Supreme Court is 109. Please note down the analogous provision. Then High Court ke liye section 96 original jurisdiction. Then there is also a second appeal lies to High Court under section 100 on substantial question of law in the Code of Civil Procedure Code. Please note that section 100. You must remember this, very important. District Court and High Court is section 96, and the Supreme Court is appeal to Supreme Court from a High Court judgment is section the provisions of 109. Then appeal from substantial question of law is 100. Then appeal from orders, that is all from decrees. Please note that a final decree, judgment and decree, it must be a final decree. The suit has been, where evidence has been recorded by the court, adjudicated, determined, parties were examined, then it becomes a final judgment and decree. It is called from the original decree where the first appeal lies. Whereas interlocutory order appeals, injunction order has been granted, you want to challenge it, you can go under section 104 of the Code of Civil Procedure. Under the scheme of the CrPC, there is no provision for appeal against interlocutory orders, but in the CPC, against interlocutory order appeal lies under 104 and order 43. See 104 to be read along with order 43 खोलेंगे आप, आपको मिल जाएगा CPC के अंदर, देख लीजिए. Order 43 has contained 41, 40, देखो 43 खोल लीजिए, अब I'll tell you. Against injunction, against appointment of a receiver where the suit has been disposed of, setting aside ex parte decree, these all provision, order 43, order 43 में rule 1 A से लेकर A B C D E F U तक है आप. Please remember this. This order 43 should be read along with order section 104. Please note, they are known as AO, appeal from orders. Please remember that. Against interlocutory orders which are affecting the rights of the parties. Whereas a mere interlocutory, whereas a mere procedural order like amendment of the plaint is a procedural order, no appeal lies. Isn't it? Appointment of a court commissioner is a procedural order, no appeal lies. That means you have no remedy. Yes, you have a remedy. You can go in writ petition under Article 227 because no revision will lie under 115. I will tell you about the provision. 115 is the provision. 115 के अंदर एक subsection है, against interlocutory order no revision lies. So when no appeal lies, when no revision lies, you should not be disheartened as a young lawyer. You have a remedy under Article 227. The High Court is exercising powers in a supervisory capacity. If the order is perverse, if there is a manifest injustice to you against your client, if there is an error apparent on the face of the record, you can tell the court, my lord, this is judgment. Either you go in review under order 47 in CPC. CPC is a very comprehensive court. 47(1) के अंदर जाइए आप, read with section 114. वो नहीं लगेगा तो आप immediately go under Article 227 procedural orders. That is possible. Yeah, whereas unfortunately under the CrPC there is no review. There is no provision for review in the matter here. Yes. Okay. Then come to no, section 376 speaks of 375 में, when the accused plead guilty, गुनाह कबूल है, then why should there be appeal? There is no appeal. He has admitted the crime, isn't it? He will be straight away convicted unless he takes up the plea that he was insane, it was fraudulently taken, he did not know the consequences. वो अलग बात है. He has to set up and prove a very difficult task. Otherwise, there is no appeal when the accused plead guilty in the 375. And similarly, no appeal under 376 in petty cases. Small minor cases, what do you want to file appeal? Notwithstanding anything contained in section 374, there shall be no appeal by conviction in any of the following cases, where the High Court passes only a sentence of imprisonment for a term not exceeding 6 months or a fine not exceeding 1,000 rupees. तो 6 महीने का sentence है in a robbery case, maybe in a major cognizable case, and normally there is no appeal. When there is no appeal in this matter, not to get disheartened, you can file a revision. Please note that here. Wherever there is no appeal, you may take up the plea that there is a manifest error apparent on the face of the record. There is a gross injustice accused to you. There is no appeal lies. Yes, your lordship be pleased to admit revisional powers under section 401 High Court ke power and 397 Sessions Court ke power. I will come to know that here. So 376 पढ़ लीजिए आप, where petty cases के अंदर no appeal lies. I won't elaborate them. There are illustrations given where the magistrate passing only fine order, sentence 100 रुपया, 200 रुपया, 1000 रुपया, minor matters, they need not be, the court need not intervene in the matter. Then appeal by the 377 is important. Appeal by the state government against sentence. When a sentence has been awarded by the court, by the Sessions Court or a High Court, Magistrate Court, whether the sentence is less or more in that regard, save as otherwise provided in the state government may, in a case of conviction on a trial by the court other than a High Court, direct the public prosecutor to file an appeal against sentence on the ground that it is hereditary. अगर sentence should have been given death penalty, खाली life imprisonment दिया है, government will feel that rape case is a heinous crime, it should have been awarded life imprisonment because following Nirbhai's case, the session judge has awarded a very lenient punishment. So the public prosecutor here, the government can file an appeal against inadequacy of sentence, but it is not, this opportunity is not given to the parties. The complainant nor the victim can file it. It is the government and the public prosecutor. Please mind in mind 377 or special powers given to the government, because the government is a protector of the rights of the accused person or of the victim. So this is with a view to protect the rights of the victim, where the inadequacy of sentence, it should have been life imprisonment should have been granted. इन्होंने खाली 5 साल दिया है. It should have been granted life 10 years punishment. He has only given 2 years punishment. You say it is adequately. It's a mockery of the rule of law and justice, and the matter calls for the intervention of the court, and appeal can be filed. The public prosecutor will take up this matter, file an appeal against this order. So to the court of session, sentence is passed to the magistrate, to the high court, the sentence is passed to any other court. So the hierarchy of the court is given here, and against the Delhi establishment means CBI is coming under the Delhi Special Court Establishment. CBI does not have its own code, unlike the Bombay police has, unlike the Delhi police has. The Prisons Act, there is a separate act passed by the Britishers which we are still following. And unfortunately, CBI, which is supposed to be the parrot of the government, does not have its own statutory law, but they are governed under the provisions of Delhi Special Police Establishment Act. You know that this is the act. You must know that this is passed under of the year 1946. Well, I think the government doesn't have time to legislate a new law for them, and they are happy with the old act. So whenever the appeal is passed, the CBI can file an appeal with regard to an inadequacy of the sentence. If the sentence is passed by the court of session, they can go to high court. High court has passed lesser sentence, go to Supreme Court. If the magistrate has passed a sentence, magistrate has power to pass sentence up to 7 years. All of you know that here, maximum. He has only awarded only 1 year in a case which warrants about maximum punishment. The CBI, the public prosecutor, can file an appeal to the concerned court in that regard. Please, Adam. Then important देखिए 378 में appeal in cases of acquittal, ये सब देखिए conviction के ऊपर आपने 372 onward से the section 372 से लेकर 377 आप these all in conviction cases where the magistrate, where the session judge, where the honorable high court, where the have given varying sentences in the matter. Of course, when the Supreme Court of India is convicting a man, now you have a right to file a review petition under the Supreme Court rules. If the review petition is dismissed under the scheme of the Constitution and the judgment developed by the Supreme Court, you can file a curative petition, which a full bench of the Supreme Court, which is Yaqub Memon's case, it was exercised, it was rejected. In many such cases, on a couple of cases, it is also allowed. You may check it up. I will tell you in what cases the curative petition was allowed, where the court says that here the earlier bench, the larger bench, or maybe a smaller bench has committed an error. The law has changed below the bridge, and the matter calls for reconsideration. The curative petition has been entertained by the Supreme Court in some cases. That is the last remedy. Uske baad nothing else. The remedy is the constitutional remedy. You can go before the President of India for clemency petition. You can go before the governor of the state for clemency, maaf karo baba. That is happened. You all know that here, clemency petition is the last resort. Yeah, that will happen. In some cases, such clemency is granted, mostly it is rejected. 99% it is rejected. In some cases, rarest of rare cases, yes. If the death sentence has not been executed for 10 years, 15 years, Supreme Court itself, suo motu, takes the matter. It says that it's a violation of his right to life and liberty. So death sentence has been commuted to life imprisonment. In many cases, even the President of India does it in many cases. Now there is a clamor here in the case of the convicts of Rajiv Gandhi, the Prime Minister Rajiv Gandhi's assassination case. There is a petition filed in the Supreme Court, Madras High Court, that she may be let off. And in fact, the wife of Mr. Rajiv Gandhi, Sonia Gandhi, has consented the family members. We have no objection if the convict is granted parole or maybe clemency, or she is forgiven, we have forgiven her. So whatever it is, that can be, it is up to the Supreme Court and the High Court respectively who to decide the matter in that regard. So now we now deal with the 378 onwards, which speaks of appeal in cases of acquittal. Suppose you are a complainant, you filed a case against me, I am acquitted. So I am acquitted, then you are an aggrieved person. The 377 speaks of a case where sentence is given less, instead of given life imprisonment, death penalty, आपने उनको 5 साल 6 साल देके छोड़ दिया. So you are an aggrieved person. You may make a representation to the government. Then the public prosecutor will take it up. Government pleader will file the appeal. That is called inadequacy of the sentence. Only the government pleader can file it on behalf of the government. Please note that. Now 378 is very important, where special leave needs to be taken in cases of acquittal. माफ कर दिया. Check bouncing case file किया आपने आपके client की तरफ से, magistrate के पास. He has been acquitted honorably. Your remedy is to go in appeal. To appeal that appeal, where does it lie? I will tell you here. See now. Now, save otherwise provided in subsection 3 and 5. District magistrate may in cases direct the public prosecutor to present appeal to the court of session from the order of acquittal passed by the magistrate in respect of cognizance of non-bailable offences. So, where in non-bailable offences, who can file it here? District magistrate means collector will do that here, or a commissioner of police will direct it here. Acquittal ho gaya, to that is the powers are given to district magistrate. So district magistrate in Bombay is either a collector or a commissioner of police. The government has issued. So he may direct the public prosecutor, please file an appeal here. Then the state government may, in cases, direct the public prosecutor to present the appeal to the High Court against the appellate officer on acquittal by the Court of High Court, not being an order under the acquittal. So under clause B, the state government, a government of Maharashtra will direct the public prosecutor that this man has been acquitted, you file an appeal against this matter to the Honorable High Court. If the High Court had done it, to the Court of Session. Then subclause 2 check. If such an order of acquittal is passed in cases in which the offence has been investigated by Delhi Special Police Establishment Act. Now CBI is investigating many cases. In almost every case, for Sushant Singh murder case mein CBI aa chuka hai. Isn't it? In every case where the ministers are involved, the CBI, central government like to appoint a CBI. So when the acquittal take place in many cases now, 2G scam, 3G scams ke andar kya hua? These all they are acquitted. So the CBI can file an appeal to the concerned court. Magistrate ne, special court ne order pass kiya, he will go to the High Court. If the High Court has acquitted him, go to the Supreme Court of India. Then to the Court of Session from the order of acquittal passed by the magistrate. So the first Court of Appeal from the order of acquittal is normally the Court of Session, acquittal passed by the magistrate in the non-bailable offences. Please note that. Understand this word. Non-bailable offences mean where offences are punishable for more than about 2 years ago, about more than 2 years. 2 years and above. You know that section 2WF and everything. Then to the High Court from the original or appellate order of the acquittal passed by the court other than a High Court, not being an order under clause A, or order of acquittal passed by the Session and Revision Court. So here the appeal would lie directly to the High Court. Directly to the High Court. It doesn't go to the Court of Session where the order is passed. Where the order is passed by the Court of Session in revision. Revision court में acquit कर दिया Sessions Court ने, और then the matter will go to the High Court directly. Then number 3 is very important. No appeal to the High Court under subsection shall be entertained except with the leave of the High Court. Here now even your check bouncing cases के अंदर acquittal भी हो गया, they will come under subclause B to the High Court. Appeal will lie to the High Court in this matter here. Because this is not a case which is a non-bailable offence, which is a warrant triable case. It's a summon triable case. A summon triable case, appeal would lie to the High Court. Please note that. You cannot file it in the Court of Session. Remember that. An appeal would not lie as a matter of course. Appeal ke saath mein, you will have to take out even a criminal application, that is leave to the Honorable High Court, placing on record the appellant who had filed the proceeding for example a criminal case before the before the magistrate court in a summons case. The accused has been acquitted. It was a 138 proceeding check bouncing case. It was evidence was led, documents were tendered, and unfortunately the learned magistrate has given an erroneous finding that the complainant has not proved the case, and the accused was discharged. The accused was acquitted. the acquittal is erroneous, the findings are erroneous, the learned magistrate has not marshaled the facts of the case, there is an error apparent on the face of the record. This honorable court therefore be pleased to admit the appeal on behalf of the appellant, and separate application a special leave be granted, because under subsection 3 of the provisions of section 378, the appeal would not lie as a matter of course. You need to take a special leave of the court. This honorable court be pleased to grant leave means permission to the appellant to file this appeal. You have to give the reason why special permission should be given to you. It should be that the learned magistrate has committed gross error of law. There is apparent on the face of the record. He has not correctly marshaled the document. He has not appreciated the primary evidence, secondary evidence. He has come to an erroneous finding. The finding recorded at page number so and so is against the spirit of the case, is not warranted. ये सब चीजें लिखना पड़ेगा आपकी अपील के अंदर. Then normally the High Court grants leave to the people here. Then, if such order of acquittal is passed, in any case acquitted upon a complaint, the High Court on the application made to the complainant and is upon special leave permission. So, subsection 4 also speaks of a cases ever complaint cases. Complaint cases mean where someone's cases, complaint cases which are not warrant cases. So we learned it. What are the warrant cases? What are the summons cases? What are the cases triable by the magistrate on a warrant, on a police report, non-police report, summon cases, summary cases. Summary cases means that normally no appeal lies in many cases, petty offences, isn't it? So here I gave you an example of a check bouncing case, which is a summons case, or a defamation case which has been rejected by the court. In a defamation case, the accused has been acquitted. Then your complaint will come to your appeal will come to the High Court directly. So you don't have to go to session. But in case of conviction, the accused will file the appeal in the court of session. Please note that different terminology, different section will apply, because the appeal will lie in conviction under the provisions of section 374 subclause 2, whereas in case of acquittal under section 378 subclause 4. Remember this, because you are being acquitted here, acquittal appeal will lie here along with the special leave petition. Remember this. Then time limit is given here. After expiration of no application to leave so and so, acquittal shall be entertained by the High Court after expiration of 6 months in a public case, or a 60 days. So 60 days is the time limit given to file. In the case of a public servant, 6 months, because public servant files move slowly, they need to take the permission of the bosses. A special attention is accorded, permission accorded to public servant, naturally, because they need to take the permission of the bosses and the central government, state government. So some latitude must be given to them, and rightly given so. So in cases of individuals and companies, people who are not public servant, they should file it within 60 days in the matter. Please note that from the date of the acquittal. Please note that. Also, the provisions of Limitation Act should be remembered. If you have the Limitation Act, keep your Limitation Act ready with you. Tomorrow in the last lecture में आप Limitation Act रखिए, and I will tell you both for CPC and CrPC there are certain provisions laid down there. What are the provisions for appeal and what is the limitation period? Okay, then 379 में आ जाइए. Appeal against conviction by High Court in certain cases where the High Court has no appeal, reverse an order of acquittal against a person on conviction sentenced to death, imprisonment of life to 10 years, he may appeal to Supreme Court. So 379 speaks of a special case where conviction recorded by the High Court, appeal will naturally go to the Supreme Court of India. Then special right of appeal in certain cases. Notwithstanding anything contained in this chapter, when more than one person is convicted on trial, an appealable judgment has been passed in respect of any of the such cases, all of them convicted of trial court shall have a right to file. So in a joint trial, many people are convicted, some people are let off. So 380 is the person here. So the all persons have a right of appeal here in the matter. Appeal to the court of session, how heard. So hearing procedure is given here. 381 is the procedure how the session judge will hear the matter. Conviction trial के लिए, so the chief metropolitan magistrate entire record must be brought. and petition is approved by the court. Then a petition of the appeal, how the appeal is drafted here, a memorandum, normally memorandum of appeal is drafted, then grounds are taken up, grounds के साथ में the grounds on which the appellant begs to challenge the present appeal. I mean, you must how it is normally the present appeal is being filed by the accused person, by the appellant, challenging the judgment and order of the conviction recorded by the court of learned magistrate or magistrate inter alia on the following among the other grounds. Yeah, that the impugn order is not in accordance with law. The impugn order is against the spirit of the law. The impugn order has not taken into consideration the judgment of the Honorable Supreme Court. The impugn order does not marshal the facts of the case. The impugn order, the London magistrate or a session judge does not take into consideration the evidence led before the parties. The impugn order suffers from the vice of several legal infirmities. So these are the grounds. Then last में देखेंगे there is a violation of principles of natural justice. On the aforesaid grounds or any other grounds that the appellant may be permitted to urge, add, amend, delete, that this honorable be pleased to set aside and quash the judgment and order passed by the learned session judge, learned magistrate, and the present appeal may kindly be allowed. Please note that when the appeal, when recorded conviction के अंदर, you should know that make an application for suspension of the sentence. Suspension of the sentence के लिए अलग से करना पड़ेगा. Because once the magistrate session judge is convicting you, you will be taken in jail. Normally you're taken in jail. उसी टाइम पे बोलने का my lord may kindly grant me bail, I had to exercise my statutory right of appeal. देखो सलमान खान केस के अंदर the magistrate, the session judge convicted him immediately and the order of conviction was passed. He was to be taken in jail. So his counsel and made application immediately that he may be released on bail for 1 week in order to enable him to move the High Court and obtain. Mere filing of appeal is not sufficient. Suspension of sentence के लिए separate application करो under section 389. Please open section 389. 389 खोल लीजिए. Pending the appeal by convicted person, the appellate court may, for reasons to be recorded in writing, order and the execution of the sentence, order up suspended, and if he is in confinement, he be released on bail on his own bond. So please, as a young lawyer, you should know this. Merely filing the appeal has no meaning. Keep a separate application. ये रखिए आप, like under this CPC के अंदर appeal file किए under order 41 के अंदर appeal provision है. If you want to stay the execution of the decree, and you must take out a separate application for staying the implementation of the decree passed by the trial court. I'll show it to you immediately. That is under order 5, order 41, rule 5 CPC. तो इसके बाद बताता हूं मैं, पहले 389 पे आ जाइए. 389 में you have to make the application. See the proviso. Provided that the appellate court shall, before releasing on bail on his own bond, convicted person who is so and so offense punishable with the death, imprisonment for term less than 10 years, shall give opportunity to the public prosecutor showing cause in writing it. So the learned judge, before releasing the person, before releasing the appellant on bail, must give an opportunity to the prosecutor. He cannot pass the ex parte order granting a stay in the matter. So everybody should be heard. The principles of audi alteram partem must be complied with. Okay. The further proviso says that here, where the conviction is a person released on bail, shall be open to the public prosecutor for cancellation of bail. So whatever conditions of bail, he must obey it. ये application करो आप. If you don't make this application, mere filing of the appeal is not a stay, is not a suspension. So ये special permission लेने का appellate court may grant such permission on certain terms and condition. That is 389 in the CrPC. When you want to know in the CPC right now, open say order 41 खोल लीजिए बोलता हूँ. Order 41 के अंदर appeal file करे civil court के अंदर. Under section 96 में appeal होएगा. The memo of appeal is filed under order 41. Order 141 खोल लीजिए CPC. Yeah. Yeah. ऑर्डर 41 मिल गया आपको? या ऑर्डर 41 अपील फ्रॉम ओरिजिनल डिक्रीज. हाँ, प्लीज बाजू में लिख दीजिए सेक्शन 96 बाजू में. हाँ, 96 एंड ऑर्डर 41 टू बी रेड टुगेदर. यहाँ पे मेमोरेंडम ऑफ अपील फाइल करेंगे आप इन द सिविल कोर्ट चैलेंजिंग द डिक्री passed by eviction. Suppose, for example, the Bombay High Court or sorry, District Court or City Civil Court has passed a decree against you for eviction. Then you file an appeal. It may be your first appeal. It is called in Bombay High Court or a District Court. To your after giving the grounds of the appeal, then you have to take out a separate application. उसको बोलते हैं civil application in the Bombay High Court under Order 41 Rule 5. check करो आप. Stay by the appellate court. An appeal shall not operate as a stay of the proceeding under the decree so and so, except the appellate court may order, nor shall execution be stayed by the only of an appeal court. So it is a condition precedent that merely because you have filed the appeal, ipso facto there is no stay. A separate application for stay should be filed also in the Code of Civil Procedure, placing on record that the appellant has filed the above appeal against the judgment and order of the City Civil Court or the District Court Bombay. The appellant has substantial chance of appeal. The appellant will suffer irreparable loss, injury, prejudice of severe nature if the appeal is allowed to be executed. So pending the hearing and final disposal of the appeal, that this honorable court be pleased to stay the execution and implementation of the judgment and decree. ये लेना जरूरी है. Like you are asking for suspension of the sentence passed by the judge by the session judge or a high court judge or a metropolitan magistrate in the appeal against conviction. Please note that here. Ye should be remembered as a young lawyer when you are appearing for the respective parties. Please note that 389 of the CrPC provides for suspension. Then appellate court has power to can try the appeal. 391 में बताया मैं appeal is a continuation of the suit. It's a continuation of the original complaint. Under 391, the criminal courts, appellate court have power to record further evidence. Like under the CPC, under Order 41, Rule 27, the appellate court also has power to record evidence. See how interesting this is. CPC and CrPC go along. Under 41 check करो, Rule 27. 27 के अंदर चेक कर लीजिए आप. Protection of additional evidence in appellate court. Remember this provision. So बाजू में लिख दीजिए CrPC के अंदर ये provision है section 391 CrPC. The session judge or the high court, while acting as appellate courts, they have a right to ask for further evidence. Any party may make, the court may suo moto can that here. So that is the procedure with regard to appeal. Then how the appeals are heard finally, please note that. Then 394 speaks of abatement of appeal. So in the CrPC, there is no provision for abatement of a complaint. There is no provision for abatement of a revision. But abatement of a appeal दिया गया है. Following this section 394, but under the CPC order, there is order 22. Order 22 is a specific provision dealing with abatement. Order 22 rule 9. पढ़े आपने? If the plaintiff and defendants are not brought on record within 90 days under Article 120 after death, the suit will abate, isn't it? You have no under Order 22 Rule 9. Setting aside the abatement application, you should file within a period of 90 days time. If you don't do, suit abates automatically. Similarly, under the CrPC scheme here, if one of under 377 section finally abate on the death of the accused, अगर accused मर गया तो appeal abates. Whereas if the respondent dies, it doesn't abate. You may take up the plea that here the appeal abates, though with a view to honor the sentiments of my father and daughter, grandfather, or a person who has been convicted, and I would like to fight the case. The heirs may come on record. We would like to have his clean record. Some judgments I cited to you at the beginning of the at the beginning of my term, you please see the earlier videos in that regard. So the children of the accused can make an application to the court. I am not accepting the conviction. I would like to have the clean image of my father. Some courts have allowed it, some courts have not. So this is the abatement. This is the end. Okay, when there is no specific appeal is allowed anywhere under the CrPC, then revision would lie under 395. Dekho, reference to High Court is a different thing. Reference is normally filed by judges. A magistrate having a doubt about the proposed interpretation of a law, or session judge is having interpretation. So they may request the High Court to resolve the controversy under 395. That is the court asking the senior court, superior court, to give an opinion in that regard. So far as revisional powers, when I told you interlocutory orders, certain orders are not appealable, then you may come under 397, which is the session judge and the High Court has got wide powers to entertain and admit the revision application. Suppose the magistrate has not issued summons to you. You file a complaint, there is no process is not issued, rejected. It's not appealable order. You can come in revision under 397. Please note that here. Or in the event that the magistrate has issued process, you can come in 397 read with 401, 1499 for coming and quashing because not appealable. Remember these powers. The revisional ka main kar leta hu na, so what is the time now? It must be already 1 hour. What is the time, Kumar?
Sir, it's 8 p.m.
8 p.m. Okay, now we will stop here. It's a question hours timing, and the revision of the High Court and the Supreme Court, revisional powers of the session judge, revisional powers of the High Court, and revisional powers under the CPC, and I will take it day after tomorrow. Okay, then we can wind up this chapter with the revision bhi lenge, reference bhi le lenge. Read section 3, read section 397, 398, 399, 400, 401, 401, 402, 402, 403, 405, 405. 397 से 405 पढ़ के आइए आप. ओके, 405 तक पढ़ के आइए सीआरपीसी में, एंड सीपीसी के अंदर पढ़ के आइए सेक्शन 114, 115, 114, 115, 115, that is revisional powers. 115 पढ़ेंगे हम लोग. Then review तो पढ़ चुके हैं हमने. Order 47, 114 वो पढ़ के आएंगे. Whatever revisional powers I will conclude it on Friday. The next lecture will completely wind up with regard to appeal, revision and review and reference also. CPC के अंदर भी जो reference है 113, 114, 115 of the Code of Civil Procedure, read with provisions of Order 47, Rule 1, वो पढ़ लीजिए आप, देख ले, general provision. Now anybody want to ask me in today's questions in today's lecture and yesterday's lecture, you please most welcome to ask me. If you are not understood, any doubts are lingering or harboring in your mind, do get it clear. Push लीजिए आप. 5 minutes we can keep it for question answer. 5 to 10 minutes I am available. I am not in hurry. Push लीजिए. पूछना है कुछ नहीं. Either all of you understood, not understood the case. दो में से. Yes, कुमार, समझ में आ गया लेक्चर पूरा?
Yes, sir.
समझ में आ गया? So no doubts?
No, sir.
No doubts. Sujata, Mallika, you yourself, Vaishwani, Darshani, Madhurani, Nikhil, everybody has understood according to me, no doubts. Chalo, I'm happy, I'm glad we have made myself clear to all of you. So we'll meet up directly on Friday now. Okay, 7 to 8 p.m. We'll deal this revision in CPC and reference in CPC and CRPC both complete kar lenge. Then I will also take you the execution, suspension, remission, commutation of sentence in CrPC, और power of to appoint a placement, वो सब ले लेंगे आप. So we are now inching towards the closure of the topic, major topic. Then we'll relegate back to the inquiry before the magistrate. Then 145, 146 proceeding ले लेंगे. वो very important. Water disputes, land disputes, then analogous powers under the specific relief act under section 6 and 9, how they are connected to civil dispute, interconnected, वो ले लेंगे हम लोग. Okay, then if you all of you understood and no question, let us call it a day, and good night to all of you. Okay, बंद करूं फिर? Okay.
Yes, sir. Good night, sir.
Okay, good night. Take you.